I'm Scott Kelly. I'm a patent attorney. I'm an IP attorney with Byrne and Witcoff. We've got an office here in Chicago, also out in DC. I have a computer science background, worked in user interfaces before going to law school. So I specialize in software patents, and we do a lot of work with video game companies.
I'm Marc Whipple. I have worked in the video game industry for 20-something years at various size developers. I am of counsel to Crawford Intellectual Property Law, which is in Crystal Lake, a suburb of Chicago, and we work with smaller developers and other people in the industry. I am also a licensed patent attorney, obviously. My background is in physics and math, so I do some pretty esoteric ones, but if it's computer software specific, you should probably listen to him.
So just to sort of get a feel for the room, so how many people in here are more familiar with patents? You've applied for a patent, you own patents, you've been sued or sued others on patents? Okay, and how many people know about patents because they've seen them on the front page of Ars Technica? All right, so we're going to start with the basics here. So just to go over what we're going to talk about today, we'll walk through sort of what a utility patent looks like, what's important about it. Then we'll talk on sort of the hot topic for the last 4 years, which is, can you even patent software? What parts of this can you patent? How is every patent just dying now? Then we'll have a little interlude where I just marvel at how wonderful it is that games are real, and talk about how, as games converge with real-life technology, what issues that might raise. And then Marc is going to go through design patents, which are the new hotness in the patent world. Just as a heads up, we actually had a third panelist, Marc Raskin, but he had to step out for an emergency. So just the two of us today. So if the middle part seems a little less practice, it's because I learned it this morning. And then we've reserved some time at the end to go through some questions that we have, but we'll also, we'd like to encourage anybody, if you have any questions about this. People love to talk about, how should we protect software? Is this the right way to do it? We'll take questions from the audience, but if you have any questions as we're going through this, please feel free. So starting with intellectual property, so there are lots of different types of IP. A lot of game developers are first and foremost familiar with copyrights, and then also trademarks. Patents come up as sort of a third type of IP, but they're sort of my passion, and I think that they raise a lot of interesting issues. So patents, they're about inventions, they're about functionality, they're about what something does, not about the way that it looks or what color it has and that sort of thing. But you can also have design patents, which are a fuzzy middle area that cover the aesthetics of something, but not so much the expression, because expression is what copyrights cover. So copyrights don't cover the idea of a maze chase, but they can cover your exact expression. So the characters that you put in there, the colors you use, the language you use. But the sort of key distinction is copyrights never cover ideas, and patents kind of cover ideas. That patents are intended to cover that area, though, as we'll discuss today. If you get too close to an idea, you can lose your patent. Then there's also trademarks protecting your brand, trade dress, look and feel, trade secrets, stuff that gives you an advantage so long as you keep it secret. Contracts are also another form of IP. You can just make about any sort of deal that you want. And then still others, domain names, rights of publicity. A lot of these are going to be covered in other panels today. So turning to patents, as I said, it's all about functionality. It's all about technology. A patent, it doesn't give you the right to do whatever it is that you invented. It gives you the right to stop others from doing that. So you can exclude others from making, using, selling your invention. And it's up to 20 years from when you first file that patent that you get that right.
And by the way, it's always with any form of IP, with very few exceptions, on you. There's no patent police or trademark police or any other kind of IP police who will go and stop your nefarious competitors. You have to come and find one of us to help you make them stop.
Yeah, absolutely. So and the other thing is, nobody's just going to give you a patent. You have to go ask for one. And so as part of these requirements, you submit this patent application to the U.S. Patent and Trademark Office, and it goes through substantive examination. So they're going to look to see if you've met all of your requirements, if you've filled out the forms in all the right way, but they're also going to see, is this something that we want to grant patent on? And so that involves checking, is this the type of technology, is this the type of thing that we allow people to patent? And that used to be a very small aspect of it, but now it's become an enormous part of our business. And then they're going to see, did you actually invent this? Are you the first person to do this? Is it novel? But more than that, even if you are the first person who happened to put these two things together, would anybody else have just thought to do that? Is that obvious? Would any game designer would have known you could just combine these things and it's easy to do? Yeah. So part of that is because we have three types of patents. We have utility patents, plant patents, and then these design patents. You rarely hear about plant patents. They are totally unique beast, and you need a specialist for that. The utility is supposed to put the emphasis on the functional aspect on it, the technology aspect of it, whereas the design patents that we'll talk about later are more about the look, the shape, the aesthetics of something.
And if you want a really quick way to think about what it is that you need to fundamentally do to get a patent is, the deal with a patent is teach us, society, how to do something we didn't know how to do before, and in exchange, we will give you a monopoly on that thing for a period of time. So have you taught society how to do something that either it didn't know how to do before and it could not have figured out with routinely examining known problems? Yeah. So that's what you need to do.
And so much of the focus is on the first two steps here. Is this the type of thing we patent, and are you the first person to do it? But really the most important part of the patent is what Marc was just discussing, is you need to explain to society, you need to give us a instruction manual on how to make and use this, because that's sort of the quid pro quo. You tell us how to do this, and we'll let you be the only person to do it for 20 years. So really the most important thing that you can take away from this panel or any panel on patents is, when you're looking at a patent, the most important thing is the claims. The claims at the end are where the lawyer, the inventor, they've spelled out exactly what it is that they think they're the first to do and nobody else should be allowed to do for 20 years. So many times these technical journals will throw up an article and they'll put up figure 1 and they say, look, it's just taking pictures of objects for use in a store. But if you look at the claims, there's usually a bit more there. And so try not to get too outraged over a patent until you look at the claims. So when it comes to video games, how do patents actually apply? So patents will cover a wide range of technology, but that's all it covers, technology. So within video games, it might cover your computer AI, your graphics, the communications that you have going in there. It might cover the user interfaces, the particular ways that you receive commands from your players, the ways that you show information back to them, different things like that. Though as you'll see, UIs can also be covered by copyrights and design patents. Utility patents certainly cover hardware. That's not even really an open question. So consoles, game controllers, that sort of thing. Back when we began doing this presentation to the video game audiences, you could patent methods, goals, and objectives, gameplay techniques. In Dynasty Warriors, if you get surrounded by too many guys, it raises your power level. You could patent stuff like that. But in the current environment, it certainly seems like stuff like that is very difficult, if not impossible, to get a patent on. And then support programs were an open question last year, though that's been answered now. So level editors, mocap, animation software, the Federal Circuit has told us, yes, you can patent stuff like that. So I always like to start with an example. This is one of my favorite game patents. So in the game, so the claims relate to your character has a sanity level, and as you get damaged or other stuff happens, your sanity goes gradually down, and different things happen in the game depending on this sanity level. So this is from Eternal Darkness, an N64 game, and so as your sanity got lower, a statue would reach out and grab you, or worst case scenario, it would pretend to blue screen on you. So that's pretty scary. But this is a great example because a patent like this probably couldn't issue today. So in 2014, we had a big legal case come out, and so this is the part that Marc Raskin was going to cover. So forgive me if I missed some points. But Alice was a very big case for the software patent industry, because up until Alice hit and a couple of cases before it, we sort of thought you do anything as long as it's tied to something real, you can get a patent on it. Well, Alice told us, they sort of turned it back into, well, let's look at this patent and see what it's really about. What does it come down to? What is the gist of it? What's the idea of it? And so if you can boil a claim down to an abstract idea, then you need to see, well, that other stuff that we sort of took away, is that significantly more than an abstract idea? Or is it just, here's my idea, here's my business rule, do it on a computer? So it sort of shifted the conversation. It created this big hurdle to getting patents and to enforcing patents, where you needed to show that you were doing more than just taking an idea and doing it on a computer. So that was basically all they told us, and the Supreme Court told us in 2014. And so it threw the entire industry into disarray, because suddenly you know that there's this nuclear bomb ready to destroy your patent, but you have no guidance as to whether or not your patent is going to survive. And I'm pleased to say that things have sort of settled down a little bit since then. We've gotten a lot more case law with a lot more guidance as to what might be patentable and what's not. So looking back at last year, we had some pretty big landmark decisions that from the Federal Circuit that explain, here's where the lines are, here's what the test looks like. So things like network-based filtering can be allowable because it's improving how computers work and talk to each other. Things like an improved data storage algorithm that makes it so the computer can pull up data faster. More filtering, and then importantly to the games industry, animation support software. So this Macro case was a big deal, and we'll talk about that a little bit further. But as many as we're seeing cases allowed, we're seeing 3 times as many still get denied. So just anything where it sounds like you're claiming a series of steps that they're not grounded in computers. They could be done elsewhere. They're not grounded in making the technology work better. They're still getting killed. So you can't patent a blackjack game or certain ways of detecting fraud in business. So we'll see some more examples of that as we move on.
And let me just add one thing. Obviously there's a little bit of age difference between us on the panel. And this is something that goes in cycles. When I was in law school, we were just coming into a cycle where they were getting much more permissive about what are called method patents. A lot of what we think of as software patents are really what are called method patents, because methods are one of the things that the statute says can be patented. And for a long time, there was sort of a not really but almost rule that unless the method affected some physical object, at the end of the method you had a thing, you had built something, you had changed something, they couldn't get a patent on it. And that all changed due to some decisions several decades ago, allowing more and more business methods. And now the pendulum is swinging the other way. It will keep swinging that way, and eventually the people who have more interest in seeing it start swinging the other way will gain the upper hand. They'll complain that it doesn't work as well for them as it should, and then it will swing the other way. So if you're going to be in this industry for a long haul, just be prepared for these bizarre shifts. Alice was a big, really bizarre shift, but it's completely in character with the history of patent law development.
Yeah, I mean, that pendulum swinging is a line that we like to use a lot, and I would say there's very little debate that right now the pendulum has swung strongly against patents. There's been a lot of cases in the last 5 years that have weakened the power of patent protection. Not just this Alice decision and the guidelines that followed it, but things like fee shifting and infringement rules. So I think we can expect to see it shifting back a little bit soon, but we'll see. So the first case that I want to talk about today is this Macro case, and it's really too bad that Marc couldn't be here today because he argued this case, so he knows a little bit more about it than I do. But I'll go ahead and take a stab at it anyway. So the inventor that worked for Macro, he was a Hollywood guy. He had worked on Star Trek, and he had come up with a new way to help computers. Help computer animators make the mouths of their characters move and make the right noise depending on what dialogue they were speaking and so forth. The patent, in its own background, explained that humans had been doing this for a very long time, and that it was, you knew that if they were making an O sound, you did this mouth, and an Ah sound, it's this mouth. But he had come up with a set of rules that were able to automatically do this. And it was it was sort of recognized as revolutionary. It was a very important tool that a lot of people use. But then people stopped licensing it, and so they sued kind of the entire industry. If you work for a game company, you probably were in this lawsuit. At the lower court, they found his claims as invalid pretty soon after Alice hit, and then it went up to the federal circuit where Marc's expert advocacy got a reversal. So the federal circuit looked at this, and we have the claim here, but I sort of walked through it already. It was the fact that they were claiming a very specific approach, and it was an order of steps. They had a lot of different rules going on, but they were very specific. That was very convincing to the court. The abstract idea, what was it? It was animating a face based on rules. But there's a lot more here than just animating based on rules. There's a lot of steps that sort of move through all of it. So that was very convincing to the court. But there were a lot of good guidelines here. At its core, every patent claim is going to be about some abstract idea. If you boil it down, you take everything out, you're just left with an abstract idea. So if you go too far, you definitely can go too far, and that was one of the points here. Also, they focused a lot on the specific requirements and what comes out of the claim. As Marc mentioned, you used to need to have a concrete result. You used to need to have something come out. Well, now the standard is a little bit more, data is a thing, but you still need to have some resulting data, some resulting product. So having accurate and realistic lip animation was seen as a result. And I mean, Marc takes this as a clear signal that software is patentable. I think it's still a little bit fuzzy, but I think we're definitely getting closer to that. Just throwing in my own 2 cents, because as I mentioned, subject matter is every patent lawyer's favorite topic, so I already had a slide on this. So I reached a slightly different conclusion. To me, what is most important about this test going forward, I mean, the whole background of this patent said it is very well known to do this sort of animation, and that these rules, you get this input, you get this output. But it's really easy for skilled humans to do that. It was very difficult for a machine to do it. The innovation here was allowing a machine to do something that was difficult for machines, regardless of whether it was easy for humans. And to me, that's really what the bright line is of subject matter. And we've seen that in some examples that we'll jump to. So this is a patent that we were able to obtain for one of our developer clients, Techland, on the game Dying Light, where you're running through rooftops in Brazil doing parkour to escape zombies. So I like telling people I worked on a parkour zombie game. In these worlds, you used to have to send designers through to tag every edge or window or grappling hook point as this is something you can interact with. Well, Techland didn't want to do that, and so they came up with a method that as you're running through this world, it's always sort of scanning everything around you to see at any given time what is the coolest, best thing that you could jump and grab or slide under or do whatever. And so it's one button parkour. You're running through the world, you press A, and it just picks the best thing to keep you fluidly moving through the environment. And this is something where a skilled parkour athlete, I mean, they can do that. They just look around. Okay, I'm going to jump up there. But it's very hard for computers to make that decision. And so to me, this is a good example of sort of where we're going post-Alice is enabling computers to do something that was previously very hard.
Let me just pipe in on that real quick. By the way, that is, not to get too esoteric, but that is one really good argument you can sometimes make to the patent office why something should be patentable. Is even if it seems like an obvious solution to a problem that's well known, if it's been 30 years and nobody's solved it, that's a really good argument that maybe your solution isn't obvious as it looks. Probably the classic example of that is, peripheral to games, is that when the first computer science team decided to try to make an algorithm that allowed computers to visually recognize objects, when they were viewable through a digital camera. It was a bunch of really smart people from MIT who thought it would take most of the summer. That was in the 1980s, and it's not there yet. So if you can come up with something like that, that's actually more useful than you might think.
Yeah. So I just want to revisit one recent case. So as I mentioned, we're getting more clarity, but we're not all the way there. So this case, Recognicorp versus Nintendo, just hit 2 months ago. Recognicorp had a patent on sort of selecting components for an image, combining them all together, and a certain way of sort of transmitting the data. To them, it allowed you to reduce the amount of bandwidth and data necessary to store these. And they looked at Nintendo and they said, your Me Builder lets people pick image features and then combines them all into one thing and sends it to other players in multiplayer. So that's sort of where this case came from. The district court knocked it down under 101. There's more details in here, but we'll move past those. As being, again, one of these methods of just moving around data. That you're just doing it on a computer. I can make composite images and send them around. So no good. Went up to the Federal Circuit, and the Federal Circuit agreed. If you look at their claims, it really is just about manipulating these images. None of the stuff about less memory or bandwidth comes through in the claims. It's just reproducing images and transferring them. So the court found this is an abstract idea. It's just encoding these images, and it doesn't really improve the functioning of a computer, which seems like a bad result because they really did describe how it improved the functioning of the computer, but that wasn't part of the claims. As I said before, the claims are the number 1, 2, and 3 most important thing in the patent. So they said, all these benefits, they're not required. So claims are not patent eligible. Though we just found out a couple days ago that this might be going to en banc review, so we might get to know a lot more here. So I've got a table here in the materials, and there's also some printed versions out at the front desk just to sort of walk through the major types of IP. And so all of this, that's sort of the Patents 101. But one of the things that I'm sort of interested in talking about is technological convergence. So I sort of mentioned I want to talk about how amazing it is that games are real life now. Because for years, since the dawn of the games industry, we've been imagining solutions to problems that don't presently exist in the real world. We're showing you driving a car around, and we also need to tell you how many health points you have and how many dollars you have. And I don't yet have a heads-up display implanted in my brain, but we're getting there. And so all of these problems that game designers have been solving as far as how to convey information, as far as what to do with overlays and all this stuff, we're starting to see them in real life. And this is even more important in virtual reality because games are sort of the beachhead for virtual reality, but all the industry reports are saying that the biggest market for virtual reality and augmented reality are going to be non-game solutions, so things like designing car parts and whatnot. So as a sort of new industry, and it's not really new, this chart will show you, virtual reality has been a buzzword in patents since 1992, and it's not even more popular now than it was then. It's just been steadily, everybody wants to patent things on virtual reality. Augmented reality is a little bit newer, as you can see from the bottom chart, but the problems that people are having to solve in virtual reality, they're unique. They are unlike anything that we've had to solve before in presenting these realistic and immersive worlds to people. And it presents a lot of technical challenges that are new and necessarily come with new solutions. And that's the perfect recipe for a patent, is if you have a problem that nobody's ever solved before, and you come up with a solution that by definition nobody's ever done before, that's a patent. So I think virtual reality is an area that people really need to look at patent protection in. So, we're seeing these incredibly inventive games like Fantastic Contraption, where you can build all sorts of things that interact in weird ways. Ever since 2000 with Second Life, a lot of people like to talk about, well, what if I put a real hammer in a virtual game? There's a lot of issues there, but I think other people have sort of covered that. I'm a little bit more interested in the flip side. So we have an example here of Gibson, the guitar makers. They came up with a very specific play-along DVD, and they went after Guitar Hero. And so that was sort of the real life going after the virtual world. Well, this real patent was about a musical instrument that generates sounds. And a Guitar Hero controller doesn't actually generate any sounds besides an obnoxious clacking noise. So this was a case where the real was found to not be infringed by the virtual. And Marc's going to go through a great example where a real stun gun that was reproduced in a game, also was not found to be infringed because video game companies don't sell stun guns; they sell pictures. But we can see this going the other way. So Ubisoft went after a DVD maker who they didn't make a game; they made a series of scrolling notes, and you played along on your real guitar. But they were able to sort of assert a patent that was grounded in some of their game experience against this real world system. So unfortunately, this is one of those areas that just we haven't seen a lot of litigation activity. And part of it is that the real world is catching up to where games have been. But I think that as we see this technological convergence, we see gamification going on, we're going to start to see a little bit more of this. One of the earliest game patent lawsuits was Sega's Crazy Taxi, which would show you an arrow sort of pointing you in the right direction. But it's very easy to see how this sort of heads-up display is coming out in modern technology. So in BMW now, they're offering a heads-up display that gives you an arrow that sort of points to where your next turn is. So could you see a game company coming after a automobile maker over their use of these user interface techniques? I think in this particular example, the claim's pretty clear that it applies to games and not real life, but I definitely think this is going to be an area where there's some clashes going forward. Yes?
With respect to the heads-up display technology, the games in some cases took that from the military, from the fighter planes and stuff like that. So how does the patent work in that context if it's developed in context and the game sort of mimics it, and then
that's a really great question. So the question was the heads-up display technology in video games was inspired by previous technology in military, and that's where the whole substantive examination comes in. Is this new? Is it non-obvious? So the military, if they had this certain type of heads-up display, and then game companies came in and they sort of were inspired by those techniques and they implemented it in their games. The questions become, is it just obvious once you know that this heads-up display is out there, it's really easy to just do it in a game, then you're probably not going to get a patent. But if there are technical problems that you had to overcome in sort of translating that technology, you might be able to get a patent there. But those features are going to end up in your claims, and so you're not going to be able to then walk back and try to sue the military later for the same heads-up display or anything like that.
And I'll extrapolate that even further, that it's not common, but it has happened, and there are some really famous examples of somebody trying to patent an invention that in the real world was described in fiction years, if not decades, before, the most famous example being the waterbed, which someone tried to patent in the 1970s, but it turned out that Robert Heinlein had described one in his book Stranger in a Strange Land, which was published late 50s, early 60s, I don't remember. And the patent office literally cited the book, which describes in sufficient detail to allow a person of ordinary skill in the art, which is the test, to construct a waterbed. And the waterbed manufacturer said, well, okay, no patent, and they sent Mr. Heinlein a free waterbed just to be nice. But I, for example, have cited against a certain patent a science fiction story I read when I was a child about a certain kind of bone induction microphone, where somebody was trying to patent a non, I don't remember the term off the top of my head, but for a speaker that doesn't actually make sound. You have to be touching it in order to hear it. So it certainly can happen that it was in a military thing, it was in a movie. It's rare, but it happens. And if the thing is, it has to have described it in enough detail that you know how it works. It can't just be, oh, the idea of a waterbed. What if you slept on water? That's not enough. He actually described in the book how the waterbed worked, even though it didn't really exist. So it certainly can happen, whether it's previous technologies or fiction, but it has to tell us in enough detail that the patent claimant isn't teaching us anything we didn't already know.
Yeah, I mean, I think the first person to come up with a truly universal translator will still get one, despite the Babelfish in Star Trek. So, but yeah, I mean, that enablement, the disclosure is really important. But so that's a really great question, and that is a good time to remind everyone that the claims really are everything, because you can't just go back like that. So, and I mean, we're seeing the same thing with these heads-up displays in grocery stores. Augmented reality experiences are popping up everywhere. And I thought this was another interesting example. So we have here for a video game system a course selection, where at some point the course that you make sort of sends you down certain branching routes, but you always get the option to go back and replay any course to get a higher score. So, you know, this is from Star Fox 64, where you could go for the score attack. But I think that we could see this come out elsewhere. So as gamification becomes a big deal, as our everyday task, we're trying to add goals and objectives and score tracking and whatnot. You could see this in a lot of other applications, such as you know, online education, where you have to, as you're sort of progressing towards your degree, you can retake certain classes to improve your score, or get maybe in certifications, that sort of thing. I think there are a myriad of other applications. As I mentioned, I think the biggest market for AR, VR is going to be non-games, but you can see how the innovations that we're making in the gaming space can certainly be applied. Allowing Minecraft to rise out of the floor in your room and allow you to interact with things and detect what you're touching, that very easily could apply to virtual surgery or virtual product design. So it's one of those areas that's kind of academic at this point, because nobody's done these lawsuits, but I think it's definitely something that we'll see going forward. And I think we'll get to our sort of hypothetical questions at the end. And there's some other resources in the material that you can check out, but I'll turn it over to Marc.
And I'll just add on that VR thing, maybe I'm just a little more cynical than my co-panelist. The thing that worries me is not that we won't have lots of amazing VR and AR inventions. We totally will. It's that there's kind of a joke in some circles of patents where you say, I am patenting X in a video game, when X is a well-known technique. Probably the worst example for any of you who are familiar with computer science is there is a patent for the memory management technique normally known as garbage collection, but it's if you are making a game and your game does garbage collection, that is a patent. And of course, that technique was invented sometime in the 1950s. And the patent literally is only about, you know, doing it in association with a video game. And I'm worried that we're going to see patents for X in virtual reality. And those will be the problems, not the amazing new technologies. So that worries me.
A lot of those patents are clearly they have some problems, and they probably shouldn't come out in the first place. The unfortunate thing about the patent system is once that patent's issued and they come after you, even if you are totally right, it costs you a lot of money to prove it. So that's definitely a downside to the system, though the patents like that probably wouldn't survive. But the fact is they do exist.
Especially after Alice, which might be one of the few upsides to Alice, those patents will be a lot harder to get, hopefully. Hopefully examiners will be a little more keyed to that kind of thing. And also we have a lot more examiners now, I think, with computer science backgrounds than we did once upon a time. So, hopefully. Anyway, mine is called Design Patents, the big new old thing. Design patents, see if my clicker works here.
I'll just press down when you click.
Okay. So this could be a patented invention right here, a system of transmitting information through somatic gestures. Well, we already introduced myself, but you'll see in the materials that's me. Okay. Design patents have actually been around for a very long time, more than 100 years. And historically, they existed in a time when both copyrights and trademarks were a little weaker than they are now in many ways. And we were just kind of trying to say to somebody, hey, if you come up with a very cool method or a very cool ornamental design for something which is actually useful or an article of manufacture, And that's a key distinction to make that gets confused a lot, because does utility patents require usefulness? Design patents only require that it be a, quote, article of manufacture. So it could be an ornamental object that its only purpose is to look nice, but it's still, you can get a design patent for it. But anyway, in my opinion, a lot of the functions that design patents were meant to address are now addressed by patents, by trademarks, copyrights, and trade dress. But be that as it may, we're stuck with design patents, so we should learn about them. As it says, they protect the ornamental design of an article of manufacture. And we're going to get into what exactly that means or what it doesn't mean a little bit. This is something that people have written whole scholarly articles about, and it is, again, trying to interpret a statute that's more than 100 years old and hasn't been modified since.
Yeah, I mean, I think one main point here that Marc made is design patents were not a thing that a lot of people cared about until just recently. So, I mean, Marc's going to dive into the Apple case, but they've been thrust back onto the list of things that you need to consider after for a long time being something that were just secondary thoughts.
They were something that people in the industries, like the people who sell stuff to Pier 1, they were the people who got design patents, and there were big lawsuits, and they were big money, and they were very important, but it was really very isolated as to who actually ever cared about them. Even most regular patent lawyers hardly ever dealt with them. So, until recently. Anyway, what is a design patent? A design patent is, as I said, a patent on the ornamental design of an article of manufacture. They can't protect functionality. That's what utility patents are for. If the particular shape of the object is necessary to get it to do something useful, you cannot get a design patent for it. At least that's the theory. It's not always so in practice, but that's the idea, and that you can usually have a design patent overturned if it turns out to be useful. But as he just said, that costs a lot of money. They last less time than a utility patent and way less time than a copyright. Copyrights, decades. In fact, we may see copyrights that never end. But, you know, decades or more than a century. And in my opinion, design patents are a little closer to copyright in many aspects. So that's a key point, that they last a lot less time. You do need a patent lawyer to get one. A trademark or a copyright can be filed by any knowledgeable attorney. Only patent lawyers can practice before the patent office, and these have the same sort of application process as a utility patent. Once you have one, you pretty much own that design. The defenses to design patent infringement are much smaller and much harder to claim. On the other hand, their design patents are very narrow. If you're familiar with copyrights, you know about the concept of a derivative work. There's no such thing as a derivative work of a design patent. Either you're infringing the design or you're not. If you are, then you're infringing. If you're not, then, you know, if it doesn't meet that quantum, if it doesn't get into, yes, you're infringing, then you're just scot-free. So it's a binary test. Although arguing about whether you've met it, of course, is what makes a lot of patent litigators a lot of money. The test for infringement, which is now where we get into the bizarre blending in of trademark DNA, is that it has to be such that a reasonable consumer or objective observer, or whatever test you want to use, would confuse the two items in a commercial context. So basically, if I could put them on the shelf and the consumer who knows what he's looking for says, oh, I could take this or this, it doesn't matter, then I'm probably infringing a design patent. And if they wouldn't, if it would be obvious to a reasonable observer, an objective observer, or whatever test you're applying, then you're not infringing, which is typically in IP something we only see in trademarks, which is another reason that these are so bizarre. They are expensive to get and to enforce. Now, that's very subjective. Compared to a utility patent, they are dirt cheap. Compared to a copyright, especially if you're filing it yourself, they are extremely expensive. On the order of hundreds to a few $1,000s, typically, I would say, is a fair estimate. Whereas with a utility patent, depending on what it is, you are certainly looking at thousands. You could be looking at tens of thousands of dollars. And a trademark, the filing fee, aside from your trusty lawyer, is $35 to $55. Or not a trademark, a copyright, sorry. And also, they have to be enforced essentially like they were utility patents for the most part. It's not as bad because usually you're just arguing about a design, so it doesn't get as complicated, but they're much more expensive to enforce than most copyrights or trademarks. So here's a great example. This is PS Products versus Activision Blizzard. I'm sure everybody in this room has heard of Activision Blizzard. You've probably never heard of PS Products. PS Products makes stun guns. Specifically, they make stun guns that look like brass knuckles with little zappers on them, and you can hit somebody with them, which you shouldn't do because brass knuckles are illegal in almost every U.S. state. These are for cops, military people, things like that. Activision Blizzard, on the other hand, makes a somewhat famous game called Black Ops, where you... Is that right? Which game is...
Yeah, I think it's Call of Duty Black Ops.
It was Call of Duty Black Ops. 2? Yes. It was the Black Ops Call of Duty, where one of the things you could equip a character with is a stun gun that you could wear on your hand.
Galvanuckles.
Galvanuckles, thank you. Very cool name. Probably a trademark in there, too. And you could use this. So PS Products has a design patent on their device because they don't want anybody else to make knuckles that look just like theirs. And they sued Activision. And the result, next slide, please, is first, you saw the pictures, and the court said, those don't really look a lot alike, guys, so we really don't think there's probably any infringement here. And then they said, but that's not really important because PS Products make stun guns, and this is a video game. Nobody goes to GameSpot to buy brass knuckles. Nobody goes to the cop store or wherever you buy stun gun knuckles to buy video games. There's just no chance that there's going to be any confusion here. So, we're just tossing the whole thing. This, believe it or not, was a huge win for the video game industry and augmented and virtual reality as a whole. Because if it had gone the other way, representing realistic objects in video games and other augmented and virtual realities would have been a terrifyingly risky proposition. Because everything you depict could have had a design patent in there somewhere. Unless you're going to do design patent clearance on every non-generic object you put in your game, you are at risk. I mean, it would be horrible. So it's really, really a good thing that it came down the way that it did.
Yeah, and this is actually a really interesting case because we actually got to point number 2. Because the judge could have really easily just tossed this out on, these don't look anything alike. And that's sort of the standard for design patents, so they probably could have tossed this case on these big galva knuckles don't look anything like brass knuckles. So the whole industry is pretty excited to see that they went further and they said, additionally, one thing is a physical product, the other thing is pictures on the screen. This kind of feels like they were trying to assert their design patent like it was a utility patent, right? The biggest similarity here looks like it's fist-mounted shockers, right? There's no real aesthetic similarity. So maybe if they had a utility patent, we'd get an even more interesting decision.
And now this was a case that was only made to the district court. It was not appealed. So we don't know for sure, but there also haven't been a lot of arguments with it. So hopefully this holds. But now we get into a case that a few of you may have heard of, 2 obscure hardware companies called Samsung and Apple. Oh, did you have a question about the PS Products?
Actually, it's probably just slightly beyond but playing with the facts, it's tiny bit here. Not that, but let's say it actually really was a fiction of PS Products. It even made, let's say, logo on PS Products. Where are we coming out?
Well, if you put the logo on there, a good trademark attorney is going to tear your throat out. So, yeah, that would have been over the line. But had it been an exact copy, I think that's where the court went of it doesn't matter. It's just not objectively confusable by an observer. So it's just not going to happen. There might have also been a copyright issue, depending on whether or not the product had sufficient aesthetic value to rise to the value of copyright.
Yeah, I mean, the question really highlights the interplay of all the different types of IP. I mean, this was a design patent case. That was the IP that was asserted. Like you said, if they put PS Products logo on there, the design patent result probably doesn't change. But now there's a trademark issue. If it was sufficiently expressive to put a stun gun in this shape, maybe there's some copyrights there. I'm not sure. Maybe there's some trade dress. But yeah, I mean, even if it looked a lot closer, that second point of the opinion, Activision doesn't sell stun guns. They sell pictures on a screen. They sell a moving video, and the design patent only covers this type of physical object. So yeah, I think more similarity probably wouldn't have changed the holding in this case.
Oh, yes.
So this is sort of like the science fiction. So if our culture continually moves towards some kind of virtual reality or augmented reality interface, like can you release a physical product? You also have to have like the virtual counterpart, because it's like, well, I can't buy your thing, but I can buy a virtual version of it and have it in my augmented reality.
Well, I'm about to talk about the crossover between virtual and real in design patents, which is a very interesting topic that I'm sure lots and lots of articles and court cases will come down about. As you can see, this one's called Revenge of the Virtual, because now we have Samsung and Apple are arguing about an Apple design patent that you can see there, but that design patent includes elements that are shown on the screen. They're not physical things. You know, is this an article of manufacture? And again, there are lots of law professors who have written long articles about what does that mean? Because again, that statute was written in the 1890s or 1880s. I don't remember exactly, but it's old and it hasn't seen a lot of updating. So to me, on first glance, the article of manufacture would have been the cell phone itself. The screen is the screen. What I put on the screen to me is not part of the article of manufacture. But they didn't have screens when that was written, so we don't know for sure what they would have said. As you can see, the patent, there's a little summary picture at the bottom, shows the icons in it. There's all kinds of comparisons. You know, the icons are in a grid. They have rounded edges. There's all kinds of stuff. And Apple and Samsung were suing each other also over utility patents and trade dress and everything else they could think of. Because, you know, when you're Apple and Samsung, you spend a lot of money on lawyers. So anyway, you can see that they did this, and the result, next slide please. The Federal Circuit Court of Appeal upheld a jury decision for hundreds of millions of dollars based on lots of different things, but a big chunk of that was based on design patent infringement claims, which in part include the GUI, which is a virtual object. So now there's lots of argument back and forth about whether this century-plus-old law applies to the combination of real objects and virtual objects. And the net result, by the way, was that this was sent back to the lower court, the Federal Circuit, to determine the correct legal standards to apply. It is going to bounce around in appellate hell for a while. It may even get sent back down to the trial court because the appellate court may decide that, hey, this is the proper legal standard. And the trial court didn't appeal it, so the whole trial, just chuck it. That happens in law. It's extraordinarily expensive. It's why you hire really top-tier law firms when you're going to argue in front of the Supreme Court, because it can determine a lot of money for your company.
Yeah, I mean, one of the things that this case left open is what is the article of manufacture? Is it the whole cell phone, or is it just the display? I mean, because as Marc mentioned, at first glance, an icon doesn't really feel like an aesthetic or a piece of the article of manufacture. But the way that the PTO and the patent bar have sort of justified filing design patents on icons is, you know, what is the ornamentation of this screen? It's not just a plain white canvas, it's the things that appear on it. And so there's sort of this construction where you can get design patents on icons because they are ornamentation, they're aesthetics of, you know, a device that is in operation. And so then the big question that Apple versus Samsung has raised, besides awarding an enormous verdict, is what part of that device do we get the profits from? Is it the whole phone, or is it just the OS, or is it just the mail app, or whatnot? I mean, the parts that Samsung always pointed at was, if you infringe a design patent on a cup holder, you shouldn't get the profits from the entire car, should you? And so that's sort of the question the Supreme Court wrangled with, and they completely punted on it. So we don't know. People are sort of guessing that the U.S. Attorney General's test that they submitted is what the Federal Circuit will apply, but we'll just have to see.
And, you know, I'm going to steal a joke from my colleague who you'll see in another panel. This is a knock-knock joke that every patent lawyer knows, which is, you know, Supreme Court, you know, somebody's knock-knock on the Supreme Court's door. Who is it? Court of Appeals for the Federal Circuit. reversed. The Supreme Court has not historically gotten too far into patents and many other kinds of IP. When they do, and this is typical, I mean, the Supreme Court doesn't usually take cases unless it means to reverse them. That's what you would expect. But when they reverse them, they do things like Alice, and they do things like this, and they do things like the venue case that just came down. The name of it escapes me, but
TC Heartland. And it's almost always, you're wrong, try again.
And we are going to disrupt decades worth of what we thought was established patent law. So right now, I think both from an Alice standpoint in terms of utility patents and from an Apple-Samsung standpoint in terms of design patents, I'm not sure we know anything about what we're doing. But I do know that if you don't talk to a patent lawyer who keeps up on this kind of stuff, not only do you not know anything, you will know things that are probably wrong, which is worse, way worse. So certainly if this is an area that affects you, and in many ways it is pretty much bound to, it's something that you have to keep in mind. And I did another panel a while back where I laid out methods to try to avoid IP lawsuits. And the very first surefire can't fail method was don't copy other people's stuff. So if you really want to try and stay away as far away from this as you can, try to make your own innovative stuff. So, but other than that, nobody knows.
So did you have anything to say here? Oh.
Nothing. I mean, I would say that, just as a design patent more specific question, I will look at question number 3 real quick, which is we're looking at iOS and Android products. Now, obviously, iOS products are on a very limited universe of screens, and the whole configuration of the device may be partially relevant. Android, much more diversity in shape and configuration. Then you get consoles and PCs, which are playing on, TVs and virtual reality. Then you get to virtual reality, which has no circumscribed physical parameters. It can look like whatever you want, and that will probably be relevant to design patents in particular because they're all about specific configuration. So when we get into AR, we probably won't worry about it as much unless we start allowing people to design patent absolutely virtual objects.
Yeah. So that's the end of our sort of prepared remarks. I mean, we wanted to open it up to questions, but before we sort of toss it back out, I do think that it's really important. Okay, by the way, this is not legal advice. Get a lawyer. I think it's important in this room. I mean, I hope we've gone down some sort of esoteric paths on the patents and gone really into the theory of what can you patent and what not. But, this isn't the question I want. This one. So for the people in the room who are developers, publishers, contract lawyers, everybody, I mean, why are we here? Do you need a patent? What are you going to do with it? It sounds like a pretty good way to waste $15,000. So, I mean, I think whether or not you need a patent depends a lot on who you are, where you're at, and what you're going to do with it. Because there's a lot of different things you can do with a patent besides go sue Samsung because you're the 2 biggest smartphone manufacturers in the whole world. So Marc, do you want to address that?
Yeah, and certainly when somebody comes to me and says, can I do this? The first 2 questions I'm going to ask are, do you have the money to get the patent filed? Which is, the number I like to throw around to start with is $5,000. It can go up very fast. It depends on how complicated it is, and it's something that patent lawyers are pretty good at giving estimates at. So never be afraid to ask. Yeah,
and patents are really complex. You probably don't want to write your own. There's a lot of things you can say in there that will doom you down the road and make your patent worthless.
Yeah, so you can get everything right up to the very last turn, and then you turn right instead of left, and instead of ending up in a good patentable place, you fall into the pits of hell. It's that easy to do.
Yeah, it's in the MPEB.
Yeah, exactly. And then the next question is, once you get it, do you have the money to enforce it? Because again, varies tremendously based on many, many factors. So never take any number that either of us ever says as anything other than a wild-ass guess. But, it is going to cost you $10,000 to $20,000, and that's a very low estimate, just to get a patent lawyer to the courthouse steps of a U.S. District Court and enforce your patent. Now, that being said, maybe you're like, well, I don't have that much money, and I don't know that I can afford a protracted 2-year battle over enforcing my patent. But if I get a patent and I want to sell my company or sell my game or get some investors, patents are extremely marketable. They are a nice thing to have. I mean, as are trademarks and copyright, and trademark registrations and copyrights to many degrees. But a patent, that's big mojo. That is something that you can really say, hey, look, I have a patent. Other people try to horn in on our business. We have this big stick because patents, not only are patent suits expensive, when you win, you usually win big. When you lose, you just lose, and nobody's happy. But once you have a patent, if you can enforce it, you can usually get some significant damages, assuming the other party isn't doing anything and not just being silly on a message board somewhere, in which case you wouldn't bother to sue them in the first place.
Yeah, there's a lot of formerly promising companies where the patents are sort of the only legacy left, and sometimes that's the way the system is supposed to work. You had a really great piece of technology. Somebody came in and copied it, and they were bigger than you, and they put you out of business. Well, that's one of the goals of the patent system, is to let you sort of go back and reap the benefits of your invention. There's a lot of times that it goes the other way, where a company sort of goes out of business, and then a lawyer buys their patent and goes and sues everybody in kind of questionable cases. But that's sort of the system we're in. But beyond enforcement, I mean, patents have a lot of value outside of, are you going to sue somebody? I assume a lot of people in here have been involved in deals with publishers or investors, and a big question is, do you have the IP? I mean, in games, copyrights and trademarks certainly rule the day most of the time, but if you have a really innovative game, you've got some really innovative technology, taking the game engine example. You have a game engine, what's going to stop somebody from copying it, or at least making a nice looking knockoff? Patents are good at that. Copyrights don't give you as much protection on the knockoff front, the different looking knockoff front, but patents provide that. And so investors are going to want to see that. They're not always going to want to dive super deep and see if they're going to be able to sue somebody with this patent. But being able to say that, our technology is great and we have a patent, or we've applied for a patent, that alone can pay for the cost of the patent in terms of convincing investors, convincing customers that you have some secret sauce that's worthwhile. So, I mean, as far as who needs a patent and when, they are expensive for sure, but they are the best way to protect a real novel technical idea. So when you encounter some problem that is sort of unique to you, or everybody else has been encountering, and you come up with a new way to solve it, that, like I said before, is the recipe for a patent, and it can provide a lot of advantages. A lot of game development does not need patents. You're not creating new technology. You're creating a new artistic expression. You're creating a new world built on top of a lot of technology. But there are times where you're a pioneer in a field, or you overcame some very difficult optimization problem where a patent can make a lot of sense.
Yes.
Yeah.
What type of due diligence is typically performed on the front end of developer-publisher relationship?
Oh boy. There's a whole, that's a whole panel all by itself if you want it to be. In fact, that's a whole book if you want it to be. I'm going to limit this to patents and say, for patents, oddly enough, it's not that big a deal. If your developer claims to have a patent, of course, you're going to look at it, make sure they own it, make sure it's been properly assigned to them by the inventors, all that good stuff. But unless you're really worried you have some specific reason, what you do in patents is called a freedom to operate search. Freedom to operate means looking to see if there are any patents that I might be infringing by doing this thing. And in certain cases, they make a lot of sense economically and legally. In most cases, they are prohibitively expensive, and you can never be guaranteed that you don't go out and spend $50,000, $100,000, which you can do on a freedom to operate search if you search broadly enough. And then the day after you submit it and you get ready to put your game on Steam, a new patent issues that you could not have known about because they're secret until the day they issue, and all of a sudden your game is infringing a patent. So if you have a reason, you might do what's called an infringement opinion, where you say, oh, that patent, I know about that patent. am I infringing it? But as far as saying, are there any patents I might be infringing? Yeah, there probably are, but don't worry about it.
I mean, I'll sort of echo some of that. So the freedom to operate is the tool for that. That's the diligence of, is somebody going to come after me for doing this? And there's no one size fits all. There's no complete answer to that. You can spend $5,000 to have somebody spend a little bit of time looking around to see if there's anything really clear out there that you might want to stay away from, or at least we did a little bit of a search. Or you could spend hundreds of thousands of dollars doing scorched earth, look at everything out there, give me an opinion. So that's something that you need to discuss with an attorney. As far as developer-publisher agreements, I'm not really aware of it being a part of it. It seems like one of those things that would come up when there's a special need for it. So if the particular project involved is one that's very likely to involve some sort of really novel or new technology, that would be more where the patent is involved. I think in a typical developer-publisher relationship, it's going to be the reps and warrants that Suzanne and Patrick were talking about.
And I'll throw two things in there real quick because I know we're almost out of time. One, watch out for your indemnification and warranty problem clauses in your contracts, because if they want you to absolutely indemnify against copyrights, trademarks, and patents, don't ever do that. Because again, you literally can't know these things. You should indemnify against reasonable risk, but don't do blanket indemnification.
Insurance almost never covers patents.
And yeah, there is patent infringement insurance. It is also usually prohibitively expensive, but it does exist, and in some cases it makes sense. The other thing that I want to mention real quick that we didn't really talk about, it just occurred to me, the U.S. isn't the only country that issues patents. If you're going to put your game on, Steam worldwide, it's just a matter of checking a box, and now you're selling it in Germany. There could be a German patent that you don't know about, or a German trademark, or a German copyright. Normally, that's not as big a deal, especially with copyrights, because people do think about that. But with a trademark or a patent, you could do that freedom to operate search, and that's when you're getting into the hundreds of thousands, is when you do a worldwide, an EU and North America search or something like that. So again, if you're going to distribute worldwide, especially if you have the budget, something to think about is, am I clear here? Where am I clear?
Yeah, I think the bottom line is patents are not an everyday issue in the games industry. There's something that everybody needs to be aware of, the risk of it, and they need to think about it. During the development process, during the technical development process, it's something to definitely think about. See if we are solving these new problems in a new way. If so, does this present value? Do I need to talk to a patent attorney? Where do we go from here? But it certainly is not an everyday relationship, and it's not something that you should let just paralyze your business out of fear of patents coming out of nowhere.
Yeah, you would never publish a piece of software of any kind, let alone a video game, if you really thought about the risks of patents. Just wouldn't.
Okay, guys, we're at time. So everyone please join me in thanking our speakers.